Good morning, everyone. This is Sandra, and Charles has taken an absence today, but we have a guest speaker, Amanda Luftman, who is a managing partner at Boren, Osher and Luftman. She is a labor law attorney and has many other credentials that are probably way too long for me to list here, but we are delighted to have her here joining us to tell us all about entrances and exits and what is new. I'm excited because Amanda has presented to us before and the response was remarkable. So here she is again today to educate all of us. We are recording this presentation. We will upload it onto our YouTube channel. If you would like a copy of her deck, Amanda has graciously offered that opportunity, and I will send it to you. My email is in the chat, so please ask me by email. Amanda, with that introduction, thank you for taking the day today to be with us. We're so grateful that you're here. And by the way, it is Thursday, April 27th, just to give us a date stamp. Thank you so much. And Amanda, it's all yours.
To all of the content.
Sandra, thank you so much for an overly kind introduction, as always, but it is delightful to be part of PayrollCentric's presentation, and I think you're right, not too many payroll companies want to bring in experts, not that I'm one of them, but other experts and all kinds of people to talk about topics and things that are of timely interest in their field. And today I did want to talk about a few topics and things that have changed as recently as February of 2023. So all of about 2 months ago. I will just share a tiny bit more. I'm an employment lawyer, but I actually practice on both sides, meaning I represent employees and I represent employers. And in employers in their compliance efforts, employees usually in chasing employers when they're non-compliant. I did want to share a few things, and I'll bring up a little bit of a PowerPoint here to just help us walk through. But I also wanted to tell you that generally speaking, employment law is a topic where nothing is black or white or necessarily easy or clear. And so I invite you to, if you would like, join us by camera, certainly join us by questions. And you can do that either by putting them in the chat, or you're welcome to ask a question at any time that it occurs to you. I don't mind being interrupted. I like the idea of a conversation instead of a lecture. And so if you want to participate in any moment, please feel free to do so. And with that said, I'm going to use best effort to share a screen here. Notice I say best effort, so we'll hope that this is going to work. Okay, I'm hopeful that you see the screen. Yes? Hopefully.
Yes, we can see your screen.
Okay, awesome. So entrances and exits. This is part of the interesting component of employment law is where do you think the bigger challenge lies? In an entrance to an employment relationship or an exit? What's your guess? Anyone want to be brave enough to share?
I'm not seeing anybody unmuting themselves, so I'll share. Okay. I think the exit.
Okay, and I wonder if just you could do a show of non-visible hands, but you know how you can raise your hand in the participants. How many of you would agree that it's exits? You guys think so too? So I would agree that we see way more conflicts and way more litigation arising out of the exit of from the employment relationship. We see less in the entrance or fewer pre-hiring or applicant disputes or litigation. Of course, those exist where people feel that they're not being hired for one reason or another. But generally speaking, we have a lot of potentials for things to go wrong in the exit of an employment relationship. Let's see if this is gonna, there we go. Not like you can't see the real me, but this is me in a still photograph, and then also a scanned QR code. If you would like to figure out how to find me, you're welcome to do so. So Today's agenda is I want to talk about exiting the employment relationship before I talk about entering the employment relationship. Why did I do that? That was deliberate because I think if we don't plan for the exit, it is very difficult to have a smooth and amicable exit. And everything about how you enter into an employment relationship should be considering how you're going to exit from that relationship. I think this is where many employers and many recruiters forget. They're so focused on making the match that we forget to plan for the fact that in today's society, it is not exceptionally likely that the person you hire will retire with you. And while that sometimes makes me sad, on the other hand, I still want to have a productive and fruitful relationship with the human being, both on entrance into the employment relationship and then as we exit from the employment relationship. And if I plan for the exit right away as I'm hiring and as I'm onboarding the employee, I'm a lot more likely to achieve that objective. So when I think about exiting the employment relationship, I think about following termination procedures. And there are many, especially if your employees are in the state of California. I think about separation agreements, the value of the same, and I think they're very valuable. And I think about sort of what the best practices around a termination of employment might be. And when I use the word termination, I'm not necessarily talking about just the employer firing the employee. Sometimes the termination of employment is because the employee is walking out the door. And there are some obligations that change, but the general concept is still the same. We're exiting from the employment relationship. When I consider entering into the employment relationship, I think a lot about compliance once again. I think about what documents do I need to have? What documents do I want to have? And also, I think tremendously about how people hear and process information. Some people listen, and they listen really well with their ears. They can hear it. Some people need to see it or read it. Some people need to write it or type it. But I want to allow for the possibility that there is going to be full comprehension by the employee and full disclosure by the employer of what kind of employment relationship they're getting into and the terms of the same. So new hire documents can obviously help us cement it. And of course, I'm still a lawyer, so they present great evidence at later times, even in the exit of the relationship. I think about arbitration agreements and confidentiality agreements. And again, I think about best practices. So let's dive in. Let's talk about those exits. So first, I want to talk about the termination of employment. And what are those top priorities for compliant exit? This is obviously not a complete termination checklist. Any of you who deal with exiting employees, you know that it's a little longer than 4. But I think about making sure that we have timely final pay. I think about making sure that we are paying out vacation or PTO because those, especially under California law, are considered wages. I think about making sure that we have a written notice, and some HR folks really like a change in status form. And sometimes, especially in a high volume business, those are really appropriate. Sometimes the written notice is a nicely put together letter accepting your employee's resignation. Sometimes a written notice or change in status is a letter in which you detail all of the performance issues you've been discussing over the past few weeks or months, and cementing the fact that the company decided to end that employment relationship based on the poor performance by the employee. Sometimes it's a layoff or a reduction in force, but that communication, whatever the written notice is, can really tell lawyers a story. So I think about what is contained in that written notice. Then, of course, we have a couple of requisite forms. We have to give the notice of unemployment benefits, and that's true not just here in California, but in most states, they have some sort of notice of unemployment benefits. In California, you're required to give a HIP notice if you have more than 20 employees, and that is to let the employee know what's going to happen with their health insurance following the end of their employment. And with or without an official HIP notice, the idea that you would communicate to your employees on exit exactly what is going to happen to their benefits, to their health insurance, which can obviously be of vital importance to people, can only help you create a smoother separation. So I'm going to get into a little more detail about what is new in the world of terminations of employment just this year. But before I do so, I just want to take a pause and see if anybody has any thoughts or questions about exiting employees and what the technicalities are around that.
Go ahead and unmute your microphones if you would like to ask a question, or if you're more comfortable putting it in the chat, we'll just read it. I have a question. What is HIPP is an acronym for something?
Yeah, the health insurance payment. Yeah, I forgot what the last P is for. Okay. But it's specifically designed, it's one of the few forms we get from the government to provide to employees on exit. And it's letting them know where they can find more information about securing their own health insurance. Because COBRA, which we're required to give that notice as well for employees on our insurance, but COBRA can be, if any of you have ever been on COBRA, it can be tremendously costly. Mm-hmm. So it also provides resources for people in California to find less expensive health insurance alternatives.
Okay. Are you also going to cover that this is an at-will state?
Yes, when we get to the entrance.
Okay, cool. And also the question is, please clarify the word timely pay of voluntary versus involuntary termination.
It's a really great question, and something definitely worth knowing. If the company or the employer makes the election to terminate the employment relationship, regardless of whether it's a reduction in force or whether it is a termination for poor performance, the employer is required to make payment of all final wages, that would include vacation or PTO, at the time of termination. The word in the statute is actually immediately. That's not a word that we see in statutes a lot, but there it is. So if you're going to terminate an employee's employment at 2:00 on Friday, you must pay them by live check still under California law at the time that you terminate their employment. So by about 2:05, you'll need to have a check physically in their hands. If, on the contrary, the employee is resigning, depending on how much notice you had as the employer, you may have 72 hours from the time that you receive notice to make that final payment, again, required by California law to be live check. So you will have 72 hours from the time that they told you. If you have a nice employee who gave you 2 or 3 or 4 weeks notice, and they told you what their last day of employment will be, you have to pay on the last day of employment. You do not have 72 hours from the last day of employment if you had more than 72 hours prior notice of the termination of employment.
Great clarification. Thank you, Amanda. PayrollCentric will help you in any of those situations. Just be sure you send a support ticket, and you can put urgent on there that you're terminating somebody today if you don't know how to process a manual check, which we've covered a few times in webinars, just as an aside note.
Yeah, it's just such an easy way to be, noticed in my framing here, a compliant exit. Because if we already have a rocky emotional relationship, we don't need to add violations of California's labor code, or frankly, the labor code sections of any other state in the exit. So paying attention to what the rules are and what's required can just be helpful, so you don't layer on or complicate an already tense situation. Okay, so separation agreements are one of my personal favorite topics, and I want to tell you why. A separation agreement, also called a severance agreement, is an agreement that contains a release, usually a one-way release, meaning the employee is releasing the employer from any claims the employee may have against the employer. In California, we have probably more than 25,000 rules, regulations, and laws that govern the employment relationship. This is why I said earlier, I don't think anyone is actually an expert in employment law, perhaps barring a photographic memory. And I have a good one, but it's not photographic. The chances that a company has violated some employment law or rule or regulation during the course and scope of the employment relationship is unfortunately fairly high, even if it were unknowingly and unintentional. A separation agreement is a way for the two parties to say to each other, yes, we're finished with each other. There will be no lawsuit or litigation, and we are going to part ways as amicably as possible. I am a very big proponent of a separation agreement and release for certainly any separation that is, here comes the official legal term, tricky. If you feel like there is a lot of emotion or anger or frustration around a particular separation of employment, I'm going to recommend that we use a separation agreement in that situation. Losing a job, and I'm not a therapist, I've never even taken Psychology 101, but losing a job is exactly like the loss of other major things. And from my vantage point, and granted, I deal with this particular loss all day, every day, it is probably the third most difficult loss in our lifetime, right? So I think death for sure is the most difficult loss, divorce, and the consequences, whether you're the kid or the person in the divorce, and losing a job, right? That's our livelihood. That's how we earn money. That's how we continue to live for the vast majority of us in the United States. So losing your job is a terrific loss, and people go through a lot of stages of grief when they have that job loss. If you have a separation agreement, and if you're able to obtain that with a departing employee, then we can skip the anger phase where they go and find a lawyer to find out all the things that the employer didn't do exactly perfectly throughout the course and scope of the employment relationship. So when should a company use a separation agreement? Certainly in any separation that's tricky. If you don't have high turnover, I would say always. If you're in a business that has a really high turnover rate, I always think of the poor folks who are running restaurants, and there's no business I like more than restaurants, but boy, your employee population is big, high turnover generally, right? So it would be hard to give a separation agreement, and part-time often. It would be hard to give a separation agreement to every person who worked for a grand total of 72 hours for the company. But I think that they should be part of what you're thinking about when you're thinking about the termination of somebody's employment. Again, voluntary or involuntary. So what has changed with regard to separation agreements? Well, in January of 2022, so not that long ago, but about 16 months ago, California enacted an act that they called the Silence No More Act. This, of course, was in direct response to the burgeoning Me Too movement, which has obviously kept way too many people, not just women, because there are unfortunately men who are also the victims of sexual harassment, but predominantly women, silenced and unable to tell their stories. And separation agreements, in my opinion, are not necessarily an opportunity to silence everyone. They're an opportunity to come to a negotiating table, make a deal, and walk away. The Silence No More Act says you cannot, under California law, stop or silence anybody from talking about anything that was unlawful that happened in the workplace. It's not limited to sexual harassment, but certainly it was in response to the shocking stories that kept coming forward of woman after woman after woman who didn't come forward about the sexual harassment she endured at work, A, because it was terrifying, B, because unfortunately she thought it was her fault in some way, shape, or form, and C, because to do so, she would have given up the money she was paid in the separation from the employment because it would have been a violation of her separation agreement. What changed even more is the National Labor Relations Board, which is, by the first word in its title, federal, not something that's just California-based. But as you can see here in the bottom orange of the screen, just in late February, the National Labor Relations Board ruled that employers cannot put broad non-disparagement provisions into their separation agreements. They have to be limited. And if they're in separation agreement under California law, not only do they have to be limited, but in addition to having to be limited, they also cannot silence the employee or former employee from sharing anything that is unlawful. So where does this leave you as the employer? A couple of things. Number one, we still have plenty of laws, not just in California, but nationwide, that prohibit people from defaming or engaging in defamation. So stating negative things about a company or a person that aren't true. You still can't defame. We have slander, we have libel. You still have abilities just under the law to make a claim against somebody who is going out and trashing your name, whether that's you personally or the business that you're part of. So why do we want a non-disparagement provision? This is a question I ask many clients. The law already protects you, and in addition, there are varieties of different organizations, the California State Legislature, certainly some of the judges and the decision makers by case law, the National Labor Relations Board are tightening, and reducing your ability to use a non-disparagement agreement, a non-disparagement provision in your separation agreement. If you are going to deploy separation agreements, I would think carefully about whether you're going to use a non-disparagement provision there at all, or if you're going to, making sure that it's narrowly drafted enough that it doesn't violate, and by the name of the act, we can tell pretty easily, it doesn't violate the Silenced No More California Act, and it doesn't violate this ruling that you see before you by the NLRB. So before I go to sort of next topic, any questions or anything that anybody would like to say about separation agreements?
Same thing. Go ahead and unmute yourself if you do have a question, or put it in the chat. Okay, Amanda, I see nothing. Go right ahead. Oh, wait, tricky. In tricky situations, does a separation agreement that indicates the employee cannot sue raise red flags for that employee, in effect, making the situation trickier?
Yeah,
Good question, Sherry.
I like your framing of it. Thank you for using my word tricky. This is probably the question I'm asked the single most often, which is, aren't I highlighting or flagging that we did something wrong or that there's a problem here? I think the answer depends on the presentation. And I think about who should present the idea of a separation agreement to that employee. And I always think it's your best salesperson, not because we're selling something, but because presentation can matter. And it's also the person who has the best relationship with that human being. And for me, don't forget, separation agreements have to come with legal term here. This one is the real legal term, consideration. And what is consideration? Consideration, more often than not in our society, is money. But sometimes in the employment relationship in particular, it's, we'll let you keep the phone that we purchased for you. We'll let you keep the computer. We bought you a whole home office of furniture. Instead of, picking it up and moving it and giving it to our next employee, we'll let you keep that. But you have to have valid considerations. So when I think about presenting a separation agreement to a departing employee, I think a lot about what that presentation is going to look like. John, I know that it's been a little bit turbulent here at the company, especially towards the end, but look, we're still appreciative of what you brought to the table. We're appreciative of your contributions. We want to say thank you. We know you're going to have a little bit of transition time ahead. We'd love to offer you 2 weeks of pay, and we'll obviously have to wipe it, but we're happy to have you keep your computer as well. If that's something that sounds interesting to you, I'll have our HR person, whether that's an inside HR person or you're going to have outside HR, prepare the final paperwork for you and send it to you. And when the separation agreement is presented in conjunction with what the employee is getting, my experience is far and away, most people are willing to sign. So hopefully that's a helpful answer to your question. Okay.
Sherry says great input, so thanks. That was good.
Okay, good. So I'm not even watching the chat. So Sandra, it's good that you are, because And you guys are just very tiny on my screen, so I'll let you continue to monitor that. But again, you all are also welcome to unmute and interrupt. I don't mind at any point in time. And if you're happy, you're putting it in the chat, and Sandra will tell me, that's good too. So, okay, we talked a little bit about the exit, and I gave you some sobering news about non-disparagement provisions. Let's talk about entering the employment relationship. So same, I'm not giving you obviously a complete hiring checklist or best practices, nor unfortunately am I helping you find the recruiter to help you find the person to get the job. But nonetheless, I wanted to share some thoughts about hiring practices. I am constantly surprised by how many people do not use an offer letter, and I have in parentheses here, and or the wage notice to the employee. The wage notice is a California form that you can actually find on the EDD's website or the DIR website. But even if you were going to write an offer of employment, if you think back to what I said a little, depending on how you process information, to what I said a little while ago, we all process information differently. You might think you offered the job to somebody at $17.50 an hour, and what they actually heard was $27.50 an hour. If we have a written offer of employment, which, oh, by the way, is actually mandated that we present to a non-exempt employee something in writing, including their rate of pay, their overtime rate of pay, your workers' comp insurance information, and contact information, we are a lot less likely to have a mismatch within the first few days and weeks or even months of that new employment relationship. I like a relatively straightforward, especially for lower level employees, offer letter that says, here's what you're going to do. I love attaching job duties to an offer letter because it's an amazing performance management tool. I love the idea of making sure the rate of pay is very clear. What's my vacation or paid time off policy? Do I have that? I may or may not be a big enough company to have an employee handbook, depends on what that is. But I love the idea that I'm going to have a written communication that backs up the verbal offer that I made to that employee. And again, if it's a non-exempt employee, there's certain information you're required to provide to them by law anyways. Arbitration agreements, I'm going to actually tell you there are significant pros and cons to arbitration agreements. I fall into the camp of a bias where I believe that arbitration agreements are better for employers and worse for employees. That's not a hard and fast rule, but I think of it this way. And using an arbitration agreement is using a contract or a provision to go and litigate your dispute in private school. Just like private school, it comes with a nice fee. And in California, the fee for private school has to be paid by the employer. But if you remember, I just said, I still think it's better for the employer it to be in that private school situation and to be in arbitration. That's because a jury is not generally a jury of the company's peers. We don't find as many business owners, C-suite executives on the jury. Of course, there aren't necessarily as many in our society. A jury is generally made up of the employees' peers. And for that reason, we want to think about the fact that the likelihood of a jury finding in favor of the employee is generally higher. So an arbitration agreement can be a very, very valuable tool in your exit from the employment relationship. There are also a number of plaintiffs' employee attorneys who are not excited about not having a jury, and they think about the value of the case differently when it's in front of a single arbitrator who's often been a judge for many years and has a little bit of the been there, done that, seen it before mentality. So I think there can be some very big value to an arbitration agreement, and we'll talk about what happened in law recently with those. Same with confidentiality agreements. What are you protecting? What belongs to the company? What do you care about if somebody leaves and walks out the door with it? In law school, we talked a lot about the Coca-Cola recipe. Is it a secret? It got published. Is the recipe a secret, or is how you actually make it the secret? Is it both? If you don't have a confidentiality agreement that protects your process and your formula, whatever that might be, depending on what kind of company you're working with, it is very difficult to enforce or protect or stop an employee from taking your information because you never made any efforts to protect it as confidential. So I think a lot about that agreement and including that as well. Of course, in hiring, we have a plethora of government issued forms. We have a W-4, we have a DE force, we have tax forms so everybody gets paid. If you're paying by direct deposit, your payroll company would like your direct deposit form. And then we have identity forms. Who are you as the employee? Do you have the right to work here? How are you going to show us that you have the right to work here? And then, big or small, what are your company policies? And of course, how up to date are your company policies?
Before you move on, we do have a question.
Okay.
Isn't there a requirement to give an offer letter?
There's a requirement for non-exempt employees only. So those are the ones who are entitled to overtime and who are protected by other wage and hour rules. You are required to provide them with written notice of their rate of pay, their overtime rate of pay, whether or not what your paid sick leave policy is and where it is written. You are obligated to provide them with your workers' compensation insurance information, your policy number, the contact information. Those are required, but it's not required to be in the form of an offer letter. I prefer it, although I do also recommend that we use the wage notice when we're hiring non-exempt employees, because even in the offer letter, I find that most people don't plop in what their workers' comp information is. So hopefully that answered the question.
Hopefully so. I don't see another follow-on, but feel free to put a follow-on if you would like.
Okay, so we'll talk a little bit more about them here. Anyways, so what should that offer letter do? And you asked me, Sandra, before about at-will employment. So in general, we have two kinds of employment relationships: at-will employment and fixed term. That's FIXED, fixed term, meaning I'll hire you for 1 year from the date of this agreement, 1 year from the date of this letter. I'll hire you. The entertainment world loves to do 2 years, and we'll have an option to pick up a third year, or 1+1, 1 year with an option to pick up another year. But fixed term or at-will employment, the offer letter is a terrific opportunity to clarify, what is this relationship? Most of our society chooses to use an at-will employment relationship, meaning we can hire or fire at any time. Sometimes clients want to include a notice period. Yeah, you can walk out at any time. We can fire you at any time, but we'd like 10 days prior notice. We'd like 2 weeks prior notice. We'd like 30 days prior notice. Chances are pretty good, if you're the company asking for notice, you're going to have to pay for that notice period, which is why we often see at will at any time, so that the company's not obligated to pay through a notice period. But they certainly could make that choice, and some companies do make that choice. We see that a lot in hospitals and medical practices. Frequently, doctors are bound by a 90-day prior notice. Why? You can imagine continuity of patient care, making sure that the doctor who knows what the information is that's pertinent and timely about the patient doesn't drop the patient without a transition. Again, I talked a little bit about identifying compensation, but also, what are the benefits? Do you have paid vacation at your company? Again, paid vacation is not required by law, but it is a benefit, and it's a benefit that many companies choose to deploy. Are you providing that benefit? And then, what is your paid sick leave policy? Do you have other benefits? Are you providing health care? Are you paying for 50% of the healthcare cost? Are you covering health insurance premiums? Do you have dental? Do you have vision? Offer letters are a great place to set forth all of those things, and they help demonstrate the company's compliance with employment laws. We know what we're supposed to be telling our future employees, and here we are telling them and setting that forth. So You can include confidentiality obligations inside an offer letter, and many companies make that choice. There's nothing wrong with that choice. I often see an offer letter separated from a confidentiality agreement. And as we discussed briefly, what does it do? It protects company information and secrets. It sets forth what the employee obligations are. No, you may not post our new donut on TikTok before we've released it. Thank you very much. Can't do it. If you don't have a confidentiality agreement, what prevents that employee from debuting your new flavor before you are ready to do so? Not much. Again, it can demonstrate with compliance with employment laws. And one of the reasons I wanted to talk about confidentiality agreements is this, to me, is a very nice place. If you want to use a non-disparagement provision, you still can't prevent an employee from discussing anything unlawful in the workplace, but it is awfully nice to seat it here when we're coming into the employment relationship with a lot of joy and anticipation and excitement, as opposed to when we're leaving the employment relationship. Even if we're leaving on great terms, we may have mixed feelings about what that exit looks and feels like. So I love the idea of using a non-disparagement provision here. And while no one gave me a crystal ball, I don't know anyone on the California state legislature, I don't know a number of judges, but if I were making a prediction, I think we're going to eliminate the ability to use non-disparagement provisions in separation agreements. So if you don't have it at the entrance of the employment relationship, I think you're unlikely to be able to have it at the exit of the employment relationship. So this is why you can see I'm saying setting up for your exit before you ever get to at the time of your entrance can really be incredibly helpful to you. Okay, so we talked about arbitration agreements a little bit. Here again, we had a change February 15th of this year. We don't often see a lot of employment changes in February, but we had the ruling from the NLRB on non-disparagement provisions, and we had a very meaningful ruling from the Ninth Circuit Court of Appeals on February 15th of 2023. To make it significant, if you don't know this history already, it's probably a little bit helpful to go backwards. In 2019, California enacted what was known as AB 51, or California Assembly Bill 51, whereby we added Section 432.6 to the California Labor Code. What did this do? What did this AB 51 and Section 436.2 do? It said employers could not require employees to sign arbitration agreements anymore. I just told you I think they're very valuable to employers. I'm not the only one who thinks that. And all of a sudden, the California legislature in 2019 said, nope, companies, you can no longer mandate that your employees sign arbitration agreements. As you can imagine, this caused quite a stir. It was challenged in federal court as soon as humanly possible, within about 20 days of the enactment of the law. And because our court system is not necessarily known for its speed, it has been working its way through the court. And the ruling came on February 15th, and it blocked the Assembly Bill 51. So sorry, it was enacted in 2019 and actually took effect in 2020. And the Court of Appeal said, we don't think so. You're a private employer, and employers may require employees to sign an arbitration agreement as a condition of employment. So this is one of what I think of as very few wins for California employers. And note, I wrote here in very nice big letters, as of today. I'm not sure this fight is over, but this is where it is now. So something to think about as you enter into employment relationships with your employees. So best practices, what are those? Make sure that you have an exit strategy for all of your employees, from the lowest paid, lowest level employee at your company, all the way up to the CEO. How are you going to exit from that employment relationship? Is it going to be a practice of the company to utilize separation agreements? Are you going to pay consideration? Are you going to have severance policies? Are you going to tie the consideration to seniority? We're going to pay you X for Y years of service. We're going to pay you X for Y level of influence at the company. What are we going to base those decisions on? But making sure that your company has an established exit practice for the end of the employment relationship that you're comfortable with, so that you can then consider and modify how are we coming into that employment relationship to best prepare for that exit. So the more kind of ducks in a row that you have, the cleaner your documents are. And I always like to recommend a proper, built out for your company and your needs, exit checklist and entrance checklist, and having the dialogue amongst your senior team so that you are aligned as to how you are in fact going to handle those tricky employees, going to handle the regularly departing employees, and how are you going to bring people in with the best of clarity and the most disclosures that you can have, so that we set up for seamless entrances followed by seamless exits. And that's really what I have for you today.
That was really wonderful. Thank you. I think it gave a lot of our people a lot to think about. And employment law is tricky, and employees can be tricky. And leaving a company, as you said, is really hard. And I think you made it human. It's not just black and white. It's not just the forms you signed, but it's how you manage the person and how you manage the process, both at the beginning and at the end. So those tips and tricks that you gave us are really wonderful, and I really appreciate your expertise. And Sherry says, excellent information. Thank you very much. So Sherry's pleased. So I'm sure everybody else feels the same way. And I appreciate your coming and taking the time to be with us today, Amanda. Thank you.
You are quite welcome. And if anyone has a question or something they want to discuss, I'm happy to do so. And if not, I'm happy to let you get on with your workday too.
We have a few more minutes. And so I'm going to tell you about the things to come. And as you are listening to me, you might think of a question. Feel free to pop it in the chat, because we've got Amanda for a few more minutes here, and it's a great opportunity for you to ask your questions. All right, May the 4th. Mark your calendars, set up whistles and bells. We have another guest presenter. His name is Brian Stampley. I wonder who that might be. That is my oldest son, in whom I'm well pleased. He is going to be joining us to tell us about capital for your business and navigating small business loans. He happens to be an expert in the field. And I have to tell you, last time I heard him, I was absolutely amazed at how much he knows. That means that education I paid for has paid off. So I'm really proud that Brian is going to be joining us next week. So please bring the CEO or the CFO or anyone who manages the money at your company. This would be a perfect time for them to join our webinar. Of course, we will record it, but there's nothing like live chat. And like Amanda, he does like interaction with his audience. So please join us on the 4th. On the 11th, we're going to be talking about out-of-state hires. It seems that with more companies working remotely, that is a new thing of how people are operating today. And I really want you to come to that one as well, because there are a lot of things that go along with hiring an out-of-state employee. We have to get your tax forms in order. If the state has withholding, we need to get you registered in that state for withholding tax. Most states have unemployment, so you still need to register for that. So we're going to have state-specific regulations on a broad level, and Charles is an expert in that area. And then on the 18th, we're going to revisit adding new employees and entering direct deposit and terminating employees and issuing manual checks. Kind of goes hand in hand with what we heard today. So those are the things to come. I do see that Charlotte does have a quick question for us. What would be the documents for the exit interview checklist? What documents would you recommend, Amanda?
So it will depend a little bit. That's a little bit broad. Maybe you can narrow that a tiny bit for me so I can help you with an answer.
Charlotte, would you like to ask that question directly? Let me unmute your, you go ahead and unmute your microphone if you want to ask it directly.
Hi, thank you, Amanda. Just your checklist for, the entrance is great. I was just wondering, you're talking about, consideration and the separation agreement. I didn't know if there was anything else you could add to a general list that I can make notes of.
Yeah, so for sure on the exit, you're going to want to make sure you have the notice of unemployment benefits, right? The HIP notice. You're going to have something in writing because that's required under law to tell the employee that the relationship is changing.
Right.
So you're going to have the written notice in addition. I have separation agreements as a mandatory part of my exit checklist.
Sure.
But I also have a lot of kind of soft things on there, like making sure that we immediately disable and forward emails, making sure that we, for those who are still coming in, we cut access to the parking structure or to the building, keep property, making sure that you're collecting property back. And for some, they're going to give some kind of, if they never did a confidentiality agreement on the entrance, they're going to try to get something, often in the form of a separation agreement on the exit. Sometimes people want to have an exit interview. So there can be a lot of things that kind of round out what that checklist is. I think people who, as you're starting to build it, starting to think like both the practical and the legal components and mirroring it into one really long list, I think actually can end up being very helpful and help you also gift that job to somebody else as you find it appropriate and needed.
Well said. Thank you so much. I appreciate that.
Yeah.
Okay. I just shared the link for the YouTube channel. I had that question and I put it in there publicly as well. So you might want to copy that. And it will be up and running, I hope, by the end of the week. If not, it'll be up by Wednesday of next week for sure. One of the things that I know that in an exit interview, I have had that question along with their check. Does the check have to have an explanation of what that check is for? Does on the stub, do we have to say, 20 hours paid out sick time, 20 hours paid out vacation time? Is that required also, Amanda?
It's not required, but it's a best practice. So, and that, thanks for bringing up that point. I think, Sandra, you and I have actually had this dialogue before. I like to have 2 separate paychecks, and sometimes 3 if it's a commission-based employee. I like to have one that's the true final wages. I like to have one that is a payout of any vacation or paid time off. And I do like to delineate it in the memo line so that when the employee goes and complains to a potential lawyer that they weren't paid their vacation or their PTO, there's actually a nice wage statement and a copy of a check that says for PTO or for 9.8 hours of PTO. And then I would like, depending on how the pay goes, a lot of times paying commissions separately, the employees don't think that they were paid commission. They're confident the company gypped them. And so if you have a third check that delineates, or if you're careful in your pay stub and delineate what's the commission pay versus regular wages, that can be super helpful too. And then if you're going to pay severance, I always recommend that's by separate check because we don't know for sure if the employee is going to sign the separation agreement.
Good. That's a good point. Because severance can be a slippery slope too. If, the separation agreement needs to be signed in order for them to get that check, right?
Right. And if they're over 40, we need an expiry. They have a 7-day revocation period, so we will need to allow that to lapse too before we pay them.
Okay. Perfect. Are there any other questions, anybody? That now's your opportunity. And if when we complete this webinar, if you think of something, feel free to email me or Amanda directly. Her information is on the slide deck. And if you want, we can call me and email me and I'll give you her direct information if that's okay, Amanda. I'm sure it is, right?
Absolutely.
Okay. All right. Well, ladies and gentlemen, thank you so much. You're welcome, Charlotte. Thank you so much for joining us today. And Amanda, for your time in preparing for this presentation and also giving us your time and advice during this presentation. You are so well loved. Know that for sure. And we appreciate you a lot. And
Thank
to
you.
my payroll, you're welcome. And to my PayrollCentric family, thank you for joining us. Thank you for being a part of the PayrollCentric family. Have a wonderful day, everyone. Bye-bye for now.